Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, February 20th, 2026. We're on voting list number 4, and we're going to start off with Senate Bill 68. Senator Charles, Josh, you are counsel.
Senate Bill 68 requires the Motor Vehicle Administration to include at least 5 questions related to motorcycle safety awareness on the driver skills examination required for issuance of a driver's license. The questions must address the following items: the visibility of motorcycles, proper lane positioning around motorcycles, safe following distances around motorcycles, preventing crashes with motor vehicles, and any other topic related to motorcycle safety that the MVA deems relevant. There is an amendment in your packet. It is number 443721. This just adds a D-Torch Road Safety Act to the title of the bill and a small preamble stating that the General Assembly honors the life and legacy of Donnell Torch Floyd, Jr.
Thank you, Mr. Chair. So I think this is great and I support it. I just have a quick question that just hit me. So the examination shall include at least 5 questions. Does that mean every test has 5 questions about this? And out of how many? I remember MVA saying something like they have a rotating list of questions that they put in.
Yep, Thank you.
Senator Charles, what is that?
It's just an award. It's just an award, you know, from the University of District
Please tell us, what type of an award was that?
Yes.
Senator?
It's a, Distinguished Alumni Award from the University of the District of Columbia. Yes, thank you. Congratulations. Thank you so much. But to your point, to your question, there are rotating. There's a bucket of questions, and they rotate them. It's never the same amount of questions. But the problem was there was never any questions that always showed up for motorcycle safety. So this adds even more motorcycle safety questions, and it's supposed to make them show up in the test on a frequent basis.
Okay, so it's not saying that every test shall have 5 questions. It's saying that 5 questions are going to be in that rotating list to give it more likelihood that at least one of them will show up.
Yes.
Got it. Thank you. Thank you, Mr. Chair.
Okay. So I'm just going to ask counsel then, so I think that's obviously the intent, which is good. This is now part of the legislative history, but it may not be clear in the language. I think you're probably right. So I'm asking counsel, is there a way to refine it to make that clear that it's part of the rotating set?
Yeah, I mean, you could maybe kind of tweak the language on, let's see, page 2, starting on line 16. So, it currently says the examination required under this subsection shall include at least 5 questions. You could say shall, or the examination shall just trying to, way to make it clear that you're saying that it shall draw from at least, or, the questions.
So you were asked 25 questions? Is it a universe of 25 questions, or are you going to be asked?
No, so basically they have 138 questions currently that are divided into 18 kind of categories. And they say that currently there are 3 questions regarding motorcycle safety in the 138. And I don't think it's a guarantee currently, although they say they're open to doing this, but it's not a guarantee currently that any of those 3 questions end up on the 25.
Can you say out of the, since we're adding, how many more are we adding? We're adding.
So the bill would say 5, and I understand the intent to be that 5 in the the bank of 138, or there'll be a few more now. So
Do we say at least one has to be asked during the examination? Like, how do you say that? At least one has to come up during your exam.
yeah, you could,
You want to come back and work on it? You want to work on it for just for a second?
sure.
Just give me a second to the end of it. Well, while we kind of work on just some minor language, let's go ahead and adopt the amendment 443721. Can we, seconded, is everyone okay with the amendment? All right, so now the bill's before you as amended. We're going to table it to the end of the voting calendar and come back to it. So now I'm going to go to Jamie. Let's go to Senate Bill 81.
Senate Bill 81 expands existing statutory prohibitions on specified sexual activity and sexual contact by law enforcement officers with a student enrolled at a school where the officer serves as a school resource officer.
There's been a motion for a favorable. It's been seconded. Do we need a roll call? Is everyone okay being recorded in the affirmative? All right. Senate Bill 81 passes unanimously.
Senate Bill 131 establishes under Title 15 fiduciaries of the Estates and Trust Article that unless waived by the client, the communication between an attorney and a client that acts as a fiduciary is subject to the attorney-client privilege, even if fiduciary funds are used to compensate the attorney for legal services rendered to the client. The existence of a fiduciary relationship between a fiduciary and a beneficiary does not constitute or give rise to a waiver of the attorney-client privilege for communications between the attorney and the fiduciary. Fiduciary includes a person granted authority to act for a principal under a power of attorney.
All right, there's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right. Excellent. Senate Bill 131 passes unanimously. Now I'll move on to Senate Bill 182.
Senate Bill 182 makes numerous changes to statutory provisions related to the reporting and investigation of abuse, neglect, self-neglect, and exploitation of vulnerable adults. This includes expanding reporting methods to include an online reporting portal, requiring local departments of social services to include as part of an investigation a determination of whether the vulnerable adult is at risk of harm, requiring local departments to make a finding that abuse was indicated, not indicated, or undetermined, repealing a provision that an investigation must be completed within 10 days if the report indicates that an emergency exists, and 5, altering and establishing numerous definitions.
There's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right. Senate Bill 182 passes unanimously. All right. Josh, we're going to skip down to Jamie. We're going to go to Senate Bill 298.
Senate Bill 298, the committee actually heard this bill last week and adopted a amendment that unfortunately hadn't gone through the amendment office at the time. On review of that amendment language, it became evident that the language just wouldn't work, and we really could not make adjustments to it based on what the committee had adopted. So I went ahead and went back and redrafted the amendment. And what this amendment does, it's Amendment 713220. It requires Maryland Capitol Police to notify the Secretary of State Police reasonably in advance exercising their police powers under certain circumstances. And then they would also notify certain specified agencies as applicable after exercising that jurisdiction. So this fits with the committee's intent. I ran it by Maryland Capitol Police as well. We sat down and just made sure that the language was what was intended, but defer to you, Mr. Chair.
So sponsor, seeing the amendment, is okay with the amendment? All right, excellent. Senator, okay, hold on, Senator Fulton, real quick, lit up.
So thank you. I just am curious about, to the Secretary of the State Police, does it have to say that, or can it say his designee, meaning like the local barrack commander?
Sorry.
Because I think that it'd be kind of cumbersome to contact the superintendent every time they want to go out and do an investigation.
Right. Yeah, we could absolutely do that, Senator.
Thank you.
And you're going to inline that. Mm-hmm. We'll just, it's going to be part of the amendment now, though. Can it be part of the same amendment?
Uh-huh.
Yeah. Okay. Yeah.
So this would be, if you're looking at the reprint, bill page 2, after line 26 in the new language, it would read in Roman 1, to the Secretary of State Police or the Secretary's designee.
All right. There's been a motion to move the amendment. It's been seconded. Everyone's okay adopting the amendment? Now the bill is before you as amended. Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. Okay, excellent. Senate Bill 298 with the amendment passes unanimously. Favorable with amendment. We can't say that anymore. All right. Jamie, I'm going to stick with you. Sure. Senate Bill 360. They're in and out.
Thank you, Mr. Chair. Senate Bill 360 repeals a prohibition against intentional infliction of bodily harm, permanent disability, or death on an animal owned or used by a law enforcement unit, except in the case of self-defense, which is a felony, aggravated cruelty to animals. The bill instead establishes misdemeanors that more broadly prohibit specified intentional harm, harassment of, or interference with an emergency response animal, which includes a dog or horse used by a law enforcement unit, and are subject to a broader range of criminal penalties under the bill. There are no amendments in the voting packet.
Just motion for favorable. It's been seconded. It's open now. Sorry, go ahead, Counsel. I have a question just to clarify for the record, but go ahead. Go ahead.
No, Mr. Chair,
I was just talking about you mentioned this in your description, but for like just the defense of, I mean, if you are defending yourself or someone else from this dog, those same defenses still apply.
Well, so in the existing law that's being repealed, it actually does provide for, except in the case of self-defense, intentionally inflict bodily harm, permanent disability, or death on an animal used or owned by a law enforcement unit. So that in the existing law, we do reference like an exception for defending oneself. That would be repealed. There's no corresponding exception for the new language being put in.
So I see it's bracketed out, lines 8 through 10. So what is the significance of that then?
My read of it is, without having done a whole lot of research on the legislative history and the origins of this, but what I suspect is that the General Assembly wanted to clarify that a person could defend themselves in situations where they were being attacked by an animal.
We're not hurting anyone.
Well, to the extent that a court has a question about, take a hypothetical, that a police dog or a service dog or a service animal bites or, is trampling on somebody, could create a question as to whether their conduct in, if they end up harming that animal in response to get them to stop, whether that's permissible.
Senator Hanson.
Important, Mr. Chair, and I think it's important to flesh out, because I guess if self-defense is generally available at law, and maybe if it's not clear, if the assailant is an animal and is an officer that's an animal, I certainly would want to make sure that was clear in the bill. So if there's additional language that would be needed,
So
if we remove the brackets, council, that were, if we remove the bracketed, the brackets there that had the effect of removing the existing language on lines 8, 9, and 10 of page 3, would that expression of a self-defense apply to the new language in the bill?
no, because what's actually coming out is also the prohibition, and it's being replaced by the new offense. But what you could do is just make an applicability provision, insert that into the new language. And I think the simplest way of doing that, if you just wanted to track as closely as possible to the existing language, is say this section does not apply in a case of self-defense or a person acting in self-defense.
I would be comfortable, Mr. Chair, with holding on it to get the language right on that, to make sure that we did preserve, if the need was there in the past, to make sure it was clear. I would want to make sure that we didn't lose the benefit of any clarity.
All right. So, Senator Bolton.
So I just want to be clear that when we're talking about the part that's been bracketed out, in the case of self-defense, a police dog isn't, if it's released within its responsibility, is it at the canine handler's discretion, is no different than if the circumstances rise to that level. It's no different than a police officer taking that subject to the ground. If that person fights the police officer, that's resisting. That is an assault. That is continued. That's not, it's the matter of whether or not they're seeking compliance in the same manner, whether it's verbally or physically utilizing the dog or themselves. They're seeking compliance. So I think that if you don't bracket that out, you're permitting someone to strike an animal in the performance of their duty that's doing as they've been trained to do without recourse. I mean, and again, there's certain things that require them to rise to the level of releasing the dog. And so I would take that into consideration. I don't think it's as clear cut as everybody's trying to make it, because it is no difference than a police officer taking an affirmative action of use of force, because it is a Fourth Amendment seizure of the person at that point.
I'd agree with you, Senator, that scenario sort of injects a little bit of uncertainty there. I guess there's a situation where, there's a legitimate exercise of force by a police officer using the dog as a tool, really, to get a suspect under control. And I guess, sort of the difficulty in figuring out every scenario that could come up. And I can absolutely try and work on a solution with the committee, but.
Any difference, again, if it's another, if it's a service canine, or, if it's a mounted horse unit, they're trained, to turn rearward and stomp backwards. People can't just start because they feel like, oh, this is my place, I'm allowed to stand. It is a justified use of force as far as trying to disperse or break up whatever is happening there. And I just want to be careful that we're not encouraging someone the opportunity to say, well, the horse was backing up towards me, or, yeah, I was running and I, had a weapon on me, but the dog then jumped on me, so I was able to just start beating back on the dog. Don't run.
So I'd I'd point out that there could be a situation where there's unjustified use of force too, and the law does actually contain an exception for that, for resisting. I don't think so, because my research on resisting unjustified force, that excuses a person in the commission of an assault or resisting arrest. This wouldn't technically constitute an assault, so I don't know that a court would apply that or extend that exception to resisting the dog.
The dog is an extension of the handler, so why wouldn't that fall within that umbrella?
Well, because if the existing exception only applies to an assault,
If it's
the
unjustified.
entire reason, right,
I'm just saying, if it's unjustified, the handler
Right.
all of a sudden goes rogue, lets the dog off leash, and
right.
it's an extension of the handler at that point.
Well, so backing out to the exception that exists for resisting unjustified force, if a person strikes back at a police officer during unjustified force, their defense is that what would otherwise have been an assault against that police officer is justified because it was unlawful force. I don't think that it constitutes an assault if it's against the animal, which is sort of the basis for the law in the first place. It's you're interfering with or harming the animal. An assault is something that, in my view, could only be between a person and another person. So I could imagine a scenario where a court says, this isn't an assault, this defense is inapplicable. So it may be worth sort of clarifying that, well, to Senator Folden's point, that the defense couldn't be used where the force is justified.
So if someone has a canine that they're a private citizen.
Right.
And they're walking their dog and they're irritated with somebody giving them a hard time and they cut that dog loose. They're like, sick them, go get them.
Right.
That's not an assault?
No. It's not an assault. I'm talking about the suspect isn't committing an assault.
I understand, but you said that it was in response to an unlawful act.
Right.
And an unlawful, and you were saying that, and maybe I'm wrong, but I understood what you were saying to be that once the canine would be let loose by the handler, it's no longer like an assault by the officer, which is what you were saying that the law.
No. I was saying, actually, the officer would be committing an assault there.
Yes.
He's using the dog to commit the assault. But what I'm saying is that if the person struck back, the suspect struck back at the officer, that would be an assault that is excused because of that unjustified force.
Agreed.
But if the same person strikes at the dog, because he's not striking a person, my concern would be that that's not actually an assault being committed on the dog. It's harming the dog. It would be a violation of the statute. Take it back to, what does that exception apply to? It applies to a person committing an assault, not other acts. So you may want to clarify that, because my thought would be that a court could look at it and then say, well, this defense of resisting unjustified force is inapplicable in this scenario.
That line of questioning did answer my question, because I wasn't clear on that. But does does couching it in self-defense put any sort of guardrails and clarity in terms of what sort of force a person can use against the animal? Because if it's in the rare exception where an officer is exceeding kind of the scope of their work and the line of duty, if a person is saying, I'm self-defending against the animal being deployed against me, that doesn't give them the right to do anything to the animal. Self-defense means you can use as much force as is necessary to be safe again. So if we are saying self-defense can be used, it is to be safe, right? We're not opening the gate to say that you can kill the animal if that's not necessary to be safe. But in order to have an affirmative defense of self-defense, there are some parameters to which you can go. I just want to make sure I understand what that means to include that provision.
Sure. So I think clarity would probably be the optimal way to go. On its surface, I think if you just say a person may act in self-defense, or this doesn't apply where a person is acting in self-defense, a court still has to try and figure out what did the General Assembly mean. Self-defense as a defense against a charge of, like, say, homicide or assault against another person exists at common law. So it's not specifically laid out. So I guess the court would probably be looking and wondering, did the General Assembly mean that we basically just take the common law criteria that we apply and try and apply it in this situation, or did they mean something else more broadly, like what we discussed in the colloquy with Senator Fulton? Just because you are in physical danger, you are defending yourself. Now, in that situation, it's a little bit different because while the police officer may mean to do harm, using that police dog as an exercise of force, it's necessary and proportionate under the situation to use that dog to gain compliance of the suspect by inflicting pain or physical injury. Would a court look at just the language in the statute and say, well, because they were defending themselves against physical injury, I'm going to find that them punching the dog, that there's an exception for that under the statute, even though the force was justified. So that sort of brings me back to, I think, clarity in the statute and being specific, for the court is probably the optimum route.
Thank you. Thank you.
One last, would it be beneficial if there was some clarifying language that said, like, that separated out during the commission of a crime versus not? I mean, it seems to me like if you're using this and during the commission of a crime, and your affirmative defense can't be, well, the dog was released on me and I was defending myself, so I think that would probably be like the line in the sand, so to speak.
I think that might be the right track to go on for it. If we're trying to draw that line, you may want to draw it, and I couldn't speak for how a state's attorney or defense attorneys would feel about this, but you may want to draw it on whether or not, say there's an exception to that exception where the exception just doesn't apply if the force was justified, if it was in the course of an officer using force appropriately.
I was coming into the bill here, and I thought this was an easy bill to vote for until I heard this conversation. Because even as I'm listening to what I think would make sense as a good solution, I can't help but think about the Edmund Pettus Bridge and the way those dogs were sicked on the individuals walking over the bridge. Now, under the exception you're talking about, law enforcement can say they violated the law. Under some of the things we were just talking about, it was civil disobedience, but did it justify the type of force that they were met with? And if they were to have hit or punched those the animals, would it have been justified? I probably would have said so. So you all have now conflicted me. I don't have anything to add, but it's now just the testimony before. I mean, again, it was how dare the people beat up on the poor animals? But when you put these scenarios in, it makes it much more complicated.
This is great, actually, great discussion. But so we're going to hold it, and then we'll work on some language and come back, and it's great.
Would you like me to work with it?
Yeah, yes. We'll do Senator Henson, Senator Fulton, and then Charles, you want to be on the work group on that? That'd be great. Cool, perfect. All right, so we're going to hold on Senate Bill 360. And we're going to, Shamari, I'm going to stay, we'll do 391, and then we'll do the withdrawals, and then we'll switch over to Josh again. So 391.
Senate Bill 391 authorizes Dorchester County to enter into a lease of county property without giving notice as specified, if the lease has a term of 5 years or less and annual rent up to $750. There is a letter from the Dorchester County Senators in your packet. The testimony was that they essentially wanted to streamline giving out these leases so that it's easier and don't have to go through the hassle of publishing in the newspaper once a week for 3 weeks, I think the terms are. There was an opposition filed by the MD. Right.
Thank you, Mr. Chair. I wouldn't have thought about this if it weren't for the recent news about all sorts of buildings that are being purchased by the federal government for detention centers. So I'm somewhat hesitant to say that the county doesn't have to give notice about a lease. Can we hold this?
All right. We're gonna hold it. Do they have a local, they have a local letter, delegation letter, right?
Yes.
Can we hear some of that? Just for the record, I mean, I don't know.
I believe Dorchester is the only one that has. Dorchester is the only one that has this exception.
Only one that has the exception for Dorchester is the only one that has the exception for, that's asking for, that has the exception.
Exception for leases, for not publishing the leases. No, they would be the only,
It would be the only one in 24 jurisdictions to have it?
yes.
If a county owns property and wants to lease its property, it has to give public notice that it's going to lease its property? Is that what the law provides? Intuitively, that would make a lot of sense.
Let me just look very quickly. I believe that is the case, but let me just double check.
I do think, Mr. Chairman, we just had a number of bills. I'm not if they're for or against, but I am very much for local courtesy. But I know we've had bills and we've agreed to them to let people stop, putting notices in newspapers because it's expensive and time-consuming and slow and the world's moved on. So just as a policy matter, I think it's something we're doing and it's the reality of modern life. I don't like it. It's killing newspapers. So I don't even know if Hartford, maybe there's no obligation on the county, many counties to even do, maybe Dorchester not only said they should publish this, and then they want to do it differently. Maybe other counties just don't have an obligation to publish when they're going to lease a building. And that's it, thank you. I was just asking about that.
And I'm looking at 10-312 of local government article,
Got it. All right.
subsection F.
Great.
Except as provided in paragraph 2 of this subsection, before the county makes any disposition, grant, or lease of county property, the county shall publish notice of the disposition, grant, or lease.
Can I ask a question? I'm sorry to interrupt you, I'm sorry. What property would be of no greater than $750?
Oh, that's true.
Like, what is that even? Like, what is that even?
Oh, yeah,
I guess that's the price.
That's
that they
also
lease
true.
it. Yeah.
Fair enough.
yeah, it's a good question.
And so looking at subsection F, this would be the only county with that exception.
Newspaper, does they newspaper?
And I think you're trying to look for a problem. The, the county is one of the poorest counties in the state, and they're trying to cut down on expenses. I just don't, now, it is noted that this bill has been put in a couple years in a row and has not moved. So I think that is something that we do need to note, like why it didn't move the past couple years. I think that's a fair assessment.
Things that I don't agree with. But we do go to local courtesy all the time, and here, I'll give you an example. I've never run into more issues with local courtesy than I do with, like, cameras, but even look at this office of sheriff in my county. We've had legislation in for 5 years, but it dies. Local courtesy has nothing to do with anybody else in the state, but they're making it about one person and not the job itself, the office that's held. It's been 18 years, and here, we have a very poor county that's trying to move something to simplify and streamline their own processes, and we're making this issue out of it, and there's no concerns about it. And I will add, to the senator's concern, even if they did engage in a contract with our federal partners, it is within the law. It's legal, regardless of what one's personal beliefs are.
You're sticking your finger into something that doesn't belong.
Couple of things. One, no one's saying they can't. It's all about notice. Two, yes, we do have local courtesy, but we also have a job to do. Local courtesy doesn't mean you just automatically accept without discussion, without debate, without vote, everything that comes forward. So I think it's worth having the discussion about this.
I'd like to move
Mr. Chair,
You're right about the debate, you're right about the discussion, but you used in light of, and I just think that that's wrong. I just think that is wrong.
I understand you feel that way. I think it's a valid question to ask.
The statute does, in light of council's read of the full statute, the notice is tied to some other things. The notice requires notice of the terms of the lease, the compensation to be received, and an opportunity to give objections. So the notice that would go out is not just the method of notice going to the paper, but it has some requirements in terms of the content of the notice. And the content of the notice is required across all the jurisdictions. And it does sound like the content of the notice has some material understandings for members of the public to know what's happening. We did indicate that it's for leases that would be $750 or less. So if it were under $750 or less, and let's say it were one that would be offered for $1 or for less, it would be important for the public to know who was getting that and who was getting the benefit of that opportunity from the county that was being funded on the public's tax dollars. And then for the terms of that, how long that lease were going to be extended for, what property it was going to be used for, and then most importantly, for the public to be notified of how they could make objections to that lease agreement. That would be a part of the required notice. How would the public know to do that if we were striking from them the opportunity for a notice that was giving them that context?
I'm not necessarily offended by the bill. It'll remain on this. I'm going to hold it just so I can talk to the senator, just to get some more clarity. It's not a knock on the bill necessarily. I just want to understand more about, yeah.
I think we should hold it.
Yeah.
But I think the reason we should hold it, why hasn't it passed?
Yeah, I want to know that too, so.
Not because Orange Man is bad.
No, I get that.
Okay,
I
because Orange Man was not bad 3 years ago when this bill has been put in for the last 3 times.
No, I understand
So I think
that.
it's a valid question.
Yeah, I think that's right.
In their own letter, it talks about nonprofits.
Yeah, I'm just gonna, that's what I'm saying, it's not an indictment of the bill, I just want to understand. So, yeah. So I'll talk to the senator today on the floor. Hold. All right, so Shamari, we'll stick with you. We're gonna go to Senate Bill 426.
Senate Bill 426 requires the custodian of a public record under the Maryland Public Information Act to deny inspection of a record pertaining to a divorce proceeding, including 1, an application for divorce, a financial record submitted as part of the divorce proceeding, a record of a divorce settlement, and 4, a custody order. However, the bill does not apply to a final decree in a divorce proceeding, and a custodian must release a record pertaining to a divorce proceeding to an applicant who, 1, is a person in interest, 2, is a lawyer representing a person in interest, or 3, has been authorized under a court order to inspect the record.
Second. Thank you for bringing that bill.
All right. Motion is for favorable. It's been seconded. Senator Sidney, you good? All right. Is everyone okay? Yeah. Is everyone okay being recorded in the affirmative? Yes. All right. So, all right. Senate Bill 426 passes unanimously. Just for context, though, so the last bill we were discussing, we actually did pass that last year unanimously. It just died in the House. But I'm still going to follow up. Yeah. Yeah. All right. Let's go to, that's you, Josh. So we're going to go down to.
Why don't you do the withdrawals?
Finish up with Shamari. All right, we'll do the withdrawals. So can we do them all in mass? Yep. Senate Bill 436, 458, 591, and 730 are all withdrawn. What is the proper motion for that? Just withdrawn?
Just withdraw.
Motions are withdrawn. Has it been seconded? Is everyone okay being reported in the affirmative? Okay. All right, so Shamar, we're going to wrap up with you with Senate Bill 472.
Senate Bill 472 legalizes the 2025 edition of the Baltimore County Code of Public Local Laws and any supplement to it that contains laws enacted by the General Assembly.
Yep. It's been a motion for favorable. It's been seconded. Is everyone okay?
I just want to ask something.
No, go ahead. Yeah.
Ask this.
No, absolutely.
So how do we know what the 2025 edition is and how it, I mean, what if it had something in there about how they lease their buildings to nonprofits? I mean, I'm just curious. I mean, do we have the whole list of all their laws that they're passing? Or are we just doing this in good spirit and good faith of an affirmative action that they're acting in good faith as a delegation? I'm just asking for a friend. There was, yeah.
So I can answer a little bit of that.
I definitely love that. I think, yep.
So I was looking into this because I had the same question. And so DLS, we draft the enactment, just the language, and it cures like irregularities, not substantive irregularities. No one reviews the entire code that Baltimore County has passed. And so if there are challenges, something that's, unconstitutional, then, that would be challenged in court, just like any other ordinance.
Do all counties do stuff?
I believe just the home rule counties.
What other counties?
I think just home rule.
Home rule, but home rules do it?
Yes.
Okay. I'm just-
All right, so there's been a motion for favorable and seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 472 passes unanimously. Josh, we're going to go Senator McKay, Senate Bill 480.
Senate Bill 480 establishes and provides for the membership of the Off-Highway Recreational Vehicle Recreation Oversight Board to advise the Secretary of Natural Resources on the operation, acquisition, regulation, and general oversight of trails and recreation in the state for those vehicles. The board would be staffed by DNR and has to meet quarterly.
Motions were favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Awesome. Senate Bill 480 passes unanimously. Okay, yeah, let's go back to Senate Bill 68. We amended it, and there's further language that we're working on for the test, the questions in the test.
Yeah, so just the clarifying language, if you're on the reprint, on page 2 of 4, in the new language between lines 16 and 18, that would be broken out into a new paragraph 1, and added to the end of it would be the phrase, "in the pool of questions the examination draws from." So the full thing would read, "The examination required under this subsection shall include at least 5 questions related to motorcycle safety awareness in the pool of questions the examination draws from." And there would be a new paragraph 2, which would read, "At least 1 question related to motorcycle safety awareness shall appear on the examination." So basically, they've got 5 in the pool, and at least one has to actually make it onto the 25-question test.
The amendment has been moved, it's been seconded. Now the bill is before you as amended. There's a motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right. Senate Bill 68 as amended with the amendments passes unanimously. That's a big award there. All right. All right, we're going to go. Senate Bill 101 is cross-assigned, but Senate Bill 101. That's you.
Senate Bill 101 expands eligibility for the Maryland Police Officers and Probation Agent Scholarship Program and the Maryland Loan Assistance Repayment Program for police officers and probation agents to include correctional officers, and renames the programs accordingly. Correctional officers would be subject to the same eligibility requirements and service obligation requirements that are established under current law for police officers and probation agents.
Motion's been for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 101 passes unanimously. Oh, yes, yes. All right, we'll now go on. This is going to take a little bit of explanation. So Senate Bill 111. I think you have a reprint in your packet.
So as drafted, the bill requires the Motor Vehicle Administration to engage in a specified process to facilitate compliance with state vehicle registration requirements when the MVA has probable cause to believe that a vehicle owner is a resident of the state, but has failed to properly register the vehicle with MVA and display proper registration plates. The process includes the issuance of warnings by the MVA to applicable vehicle owners within a 60-day compliance period, the assessment of civil fines by the MVA for noncompliance beyond the initial 60 days, and referrals by the MVA to local jurisdictions for potential additional enforcement actions against vehicles when the owners remain out of compliance for 120 days from the time that the warning was issued. So you have an amendment in your packet, which is number 763927. It keeps all of that in the bill and adds a number of additional provisions related to out-of-state improper registrations. So just kind of walking through the reprint. So starting at the bottom of page 1 and into the unnumbered page, there is language there that allows the MVA to take possession of out-of-state plates which are being displayed unlawfully if a couple other conditions are met. So basically the 2 conditions that have to be met for this to happen are that the registration plates were issued by another jurisdiction but are being used by a person who's been a resident of the state for at least 60 days, which is the time period in which you are required to register your vehicle. And then one of 2 additional things, either you have failed to comply with 2 or more traffic citations, or your license to drive has been suspended under 16203 of the transportation article, which is specifically for child support arrearages. So kind of mechanically how this is designed to work is when the MVA realizes that one of these things has happened, they issue what's called a tag pickup order, which is something that law enforcement can see if the vehicle is pulled over, and law enforcement would take possession of the illegal registration plates and deliver them to the MVA. I don't know if you want to go one by one or
let's
go through the whole thing.
Let's do that. Senator.
Thank you. So during the discussion we had, I think you were on the call, Josh, if I'm not mistaken. We spoke about the remote MVA businesses that are actually the ones that are probably enabling this to happen, allowing this to happen by issuing them. Is did we add anything, or did we give any consideration to adding something in, like an enforcement arm that allows them to immediately revoke their privilege, just like we would do with an alcohol violation?
Yeah, there is a piece about that later in the amendment.
Okay, all right. And then on the pickup orders, like the MVA can put a pickup order, there's a control number that comes with it that's required. Like they'll have a pickup order early on, it's like a warning. But then once they add the control number, is there language in there to like kind of just put the control number on it right away?
There is not. So what the amendment kind of mechanically does is it basically adds this to the existing statute which authorizes tag pickup orders. So I assume the MVA would have all the same authorities. Like when a registration is suspended or revoked, this is currently what happens. So I assume they would operate in basically the same way.
Okay, thank you.
So the next piece of the amendment, which starts right after that on the unnumbered page, starting with section 12-402, is amending into the bill, Senate Bill 173, which is an MVA departmental, which is intended to allow the MVA to enter into reciprocal automated enforcement agreements with other jurisdictions. So that's the new language in section 12-402 and section 12-411.1. It's verbatim what's in Senate Bill 173.
So for these, why are they not, they needed enabling language to do that? Could they have done that before without that language?
I think it's kind of unclear because what they want to do, and as you'll see in the new 12-411.1B, they specifically want to basically provide for reciprocal suspension of registrations, which is something that they, I think, reasonably believe they would need specific statutory authorization for, because they would be suspending a Maryland registration for a violation which occurs outside of the state. So I think they probably do need the new language. So starting after that, in section 13-402, there is, and this goes all the way down for a couple pages, there is language which would allow trailers to be registered outside of the state. So currently, if you're a Maryland resident and you own a trailer, which is a vehicle that does not have a mode of conveyance of its own, it's hooked to the back of another vehicle, that is required to be registered in Maryland. So what this language does is essentially say it has to be registered somewhere. You could still register it in Maryland if you wanted to, but as long as you are registered in a state, you would be good under Maryland law for a trailer.
Is that from your bill?
Farmers and obviously trucking companies that have a footprint outside the area, we don't want to start having enforcement because their trailers, even though it's hooked to the Maryland cab, it would have a main trailer tag or something like that. So thank you.
So all motor vehicles would still have to be registered in Maryland,
All
but
motor
trailers could be
vehicles.
registered in another state, but they do have to be validly registered somewhere.
And the caveat to that is, on no trailers are there insurance. All vehicles that have a mode of conveyance are required to have their own insurance, which was also another point to bring to that, because they're insured by the towing vehicle.
Right now, if you have a trailer, your trailer can be registered in any other state, right?
No, under Maryland law, I mean,
Has to be.
enforcement is another question, but under Maryland law, it has to be registered in Maryland. And what this says is, as long as it's registered anywhere in any state, it's good to drive in Maryland.
As a trailer.
Just the trailers, not motor vehicles have to be registered in Maryland.
How does that work with, you don't have to have insurance, how does that work with insurance? You don't have to have insurance?
They're insured by
the
propelling vehicle.
The car insures the trailer.
Yeah.
Just, I mean, I don't care, like, is it just
go after those that are registering vehicles in Virginia to avoid child custody or to avoid back payment, to avoid other speed camera violations.
So I'm looking at the section 12-110. A, we got 4. So what this says is that the administration can take possession of a license plate, stops a car and takes possession of the license plate that has been issued by another jurisdiction but is being used or displayed by a person, 1, who's been a resident of the state for more than 60 days, and 2, has failed to comply with 2 or more traffic citations, or 3, whose license to drive in the state is suspended under 16-203. All of which sounds good, but now I'm looking at the bill, and here the bill modifies 26-301 to say that the administration can suspend the license of a person who fails within 120 days after issuance of a warning to properly register the vehicle in Maryland. Why shouldn't we add to the first section, 12-110, a cross-reference to section 26-301 in addition to section 16-203? In other words, if someone has been, license has been now suspended because they failed within 120 days after notice to properly register their vehicle in Maryland, why shouldn't we permit the administration to take their license plate if they get stopped on the road?
Yeah, we could add that cross-reference. It's, you know, yeah, we could say, you know, you're suspended on 16203 or 26301.
Yeah.
Just kind of bootstrap language there.
I'm saying on page 2 of the bill, it says the administration can take a license plate, subparagraph 4.
Yeah.
That has been issued by another jurisdiction, like Virginia.
Yeah.
To a person, and is being displayed by a person who's been a resident for more than 60 days and who's failed to comply with numerous traffic citations, or whose license or privilege to drive is suspended under 16-203. And we're adding this similar language to a suspension in section 26-301. So why don't we add the second cross-reference there? So it not only cross-references section 16-203, it also adds a cross-reference to section 26-301.
So the bill's adding a new way to suspend your license, so I think it makes sense to say, you know, if you're suspended under either of those.
This sort of closes the loop. So if someone has failed to re-register their car in Virginia, in Maryland, as required under section 26-301, then the police have seized the car on the road and seized the license, can take the license plate off and remove the license plate.
Makes sense.
Yeah.
Yeah, so that would just be on that unnumbered page in 12-110, where it says whose license or privilege to drive in the state is suspended under section 16203. It would just say section 16203 or section 26-301.
Exactly.
Yeah.
So on the, it's the unnumbered page after page 1.
Here.
Yeah, it would be where that item 2, whose license or privilege to drive in the state is suspended under section 16203, just be saying 16203 or 26301.
So could I make that motion?
Oh, well, that's going to be part of this amendment, so.
Oh, okay.
Yeah, let's continue.
So moving on, after the trailer registration language, there's language being added to section 15-606. And to Senator Folden's point, this is the adding an explicit prohibition on tag and title companies selling out-of-state registrations. And again, to the point, it's not actually in the bill, but this does allow, you know, an immediate suspension or revocation of their license, because if they are found to have done any of the prohibited acts, the MVA can immediately suspend or revoke a license.
Does that happen?
I think what I've heard from them is they have a lot of enforcement issues because, these are, like a lot of the more legitimate companies aren't doing this. They're sort of these sort of fly-by-night. They're popping up, they're advertising, then taking down their advertisements, but, yeah.
No, I got it, yeah, yes. I didn't, I mean, that is crazy, but this is turning into be like a pretty substantial bill. This is good.
So then,
What the bill is, or?
Doubling and tripling down of penalties on people who are already poor and making bad decisions because everything costs so much. The rationale on suspending the driver's license as well, like let's say you abandon the vehicle, why would we take away the driving privilege? Because you could drive a car that was properly registered and insured and all those things were happening with a valid driver's license. The rationale to suspend their driver's license privilege, like, I would love to understand that better.
you would, so in the new language, you would have to have, I mean, and same arguments apply understandably, but you would have to have failed to comply with 2 or more citations or had your license suspended for child support arrearages, or this registration. But, those same arguments could potentially apply understandably.
We're suspending the driver's license for not registering the car properly in state. Is after they've gotten notice, they're not registering the car, we would then suspend the driver's license privilege.
If they had 2 or more unsatisfied citations, in addition to the registration issue.
And the rationale behind that is what?
As I understand it, because there are a lot of cars that are tagged out of state that are racking up.
Suspending the license if you have 2 or more citations.
The outstanding issues.
The license, you can be arrested for that. That is a jailable offense. So we do want to get them arrested.
You can be charged with a sign and go, but it is technically an arrest, yes.
Okay. I just wanted to understand the rationale there. Thank you.
Yep. Is that all the amendment, Josh?
Yeah.
Okay.
No, we're almost there. So after 15-606, there is a change to 26-201, which is the standard contents of a traffic citation. So the change is on the next page. It would require the VIN number to be part of the citation. Now, I did receive some feedback from state police. They're concerned, I think, first about a potential fiscal impact, but they also have some concerns that it's a safety issue for officers because they would have to, where the VIN is located, they have to get out in front of the vehicle. So they were a little bit concerned about officer safety, so I just want to make sure I flag that for the committee. Adding the VIN number to the standard citation.
Was it every citation, or we were talking cameras? Or we were talking about?
Every citation.
Why did you guys do that?
Well, because what was happening is that they were putting these tags on that were issued to another, or there was a discussion about why we wanted to have the VIN number on this citation, Josh, and I'm sorry, I'm kind of drawing a blank, but there was a meaning behind it because it dealt with them transitioning tags out, I thought.
Yeah, you get kind of the vehicle history as opposed to just the registration history.
Oh, that's right. We were talking about, because what was happening is that we wanted to be able to keep or track the vehicle history for past issues, and this is just adding it into the MVA database. I thought we were doing it by tag still. There's no reason that they would have to confirm before they were to tow the vehicle, but off of a vehicle registration, once they scan it into their mobile data terminal, it would pop up and show the VIN number. And so what we would then is off that VIN number, it would give the vehicle history of past violations if they were out of state. If it was a Virginia tag, it would show the past violations of Maryland. So the only time an officer would have to go up would be to confirm before they took the tags that is the VIN number of that vehicle. So it's not on every citation. I think it was a part of their MDT that they are that it automatically do a search, not just by tag of vehicle history, but it does it by VIN number of vehicle history. That was the issue. It's not a,
Okay,
it's
well-
not a physical, the only time it's a physical confirmation is if they're taking the tags or towing the
Right.
vehicle.
So it sounds like the solution may be to take this part of the amendment out then. I mean, that's something they should be able to do in their system, right?
They don't though right now. So the part of that discussion was to make it to where through, when they scan it in, that it automatically, and that's a policy thing, I think. I think they can.
Yeah, I don't think that
we have
requires
to-
a statutory
I don't think
change.
we need a statutory change. But that was the intent in that discussion was that it automatically did a VIN check secondarily to the primary tag check for outstanding violations, because that was the disconnect, was a vehicle that is registered in Maryland, here it is, a vehicle that was registered in Maryland, had Maryland tags, it has a VIN number associated with it. These people are then taking the vehicle tag off, they're going and registering the same VIN vehicle in another state because of whatever reasons we've discussed, and now it's not enforceable for any traffic, speed camera citations or anything by our own statute, and that it would do a cross-check on the VIN number to see if there was outstanding in the database. So that was a policy database thing, Josh. I mean, maybe am I not?
No,
again,
I think you're correct.
I'm sick. I'm not feeling that great, but I think that was the discussion.
So we could just take that piece of the amendment?
Yeah. Can you do that?
It's about tracking in their policy, not statute.
All right.
So there is one more piece of the amendment. So on page 3 of 3, so this is essentially adding to what was already in the bill about the process for enforcement. It's adding essentially a license suspension to that process. So the administration shall suspend the license or privilege to drive in the state of any vehicle owner who fails after that 120 days to validly register their vehicle and who has, 2 or more traffic citations. And then, the administration would be required to reinstate the license if the person properly registers and satisfies those citations. And there is one piece of this that is not in the amendment, but it came up in the hearing I want to flag. So in the existing bill on line 23 there on page 3, it allows the state's attorney to bring a civil action in rem against a vehicle owner or against a vehicle itself when the owner fails to comply with this process. And it was flagged at the hearing that the state's attorneys don't think they're the proper entity to bring that. And they suggested changing that to the county attorney. So that's not in the amendment, but want to flag that for the committee.
I know the work group worked hard on this, so what I want to do is, I'd like to adopt the amendment, but then hold the bill, so that we have further discussion, because there's definitely some unreadiness, and I personally want to understand just a little bit more about it, so if we could.
Do the county attorney thing?
I mean, no, that's another policy, just keep flagging that, though.
Adopt the amendment and striking out the one part about the.
Yeah, he's going to do that.
Page is that?
So that's it's an unnumbered page.
The sponsor?
The suspension was not in the original bill.
Okay, that was the work group, okay.
Sponsor has been made aware of the changes. Let's amend it and then hold it. Continue to workshop it, but I'd like to adopt the amendment. Is everyone okay?
Yep.
All right.
26301,
Yeah.
Yeah, the whole thing is out.
the whole first, that one page and the second page.
26201.
All right, so we're gonna, I think that's it. That'll be the end of our vote list. We already voted. Which one? Didn't we voted that?
We already voted that.
Yeah. Well, you voted for it. All right, so that'll conclude our voting session. Stand by for floor leaders.